Does it matter in your divorce who files first? I want to start off by saying if the other party files the divorce first, your case is not lost. We would build our case around your goals and we would still fight your case. But that said, there are some tactical advantages to filing the case first. So strategically, filing the case first allows us to set the tone and tempo of the case from the beginning. So let me give you an example. Oftentimes when people come into our office and say, hey, my spouse is filed for divorce and I got served with these papers, we take the papers and I can look at those papers and say, okay, this is a pretty mild petition, right? This is pretty innocuous and it looks like pretty low conflict. I can also look at their petition, depending on what they asked for in their pleadings, and say, okay, this is pretty middle of the road, nothing to be alarmed about. I can also look at it and say, holy smokes, this is a really heavy pleading. They are asking for everything. They are going for the jugular, okay? So just based on the things they asked for in their pleading, I know that they are expecting a very high conflict divorce. We like to use those initial pleadings to set the tone that our client wants. If our client wants a nice low conflict divorce, then we're going to plead asking for a low conflict divorce. If our client has been abused and has been assaulted and we think the other party has been hiding money and has done all kinds of terrible things, then our petition is going to be very heavy. We're going to ask for a lot of relief, and basically we're wanting to stick it to the other spouse as hard as we can in the divorce. So we can build the divorce pleadings in a way that our client wants them built. That doesn't mean the other side won't come back heavier than we expected, but if the other lawyer sees our pleadings and sees that our pleadings are really mild or standard or really heavy, then they will know how to respond to us in a thoughtful way, fingers crossed. As far as other tactical advantages, filing the case first, we always ask for a hearing during our initial pleading, almost always, and we go to that hearing, we get to talk first. So we get to put on our first witnesses. The judge might call us all up to the bench and say, what do we got? What's going on? And we'll say, well, Judge, this is our hearing. My client just wants this, this, and this, and then we're done for today. So, it can be easier for us if we get to tell our story first. If there are bad facts, if it's a high conflict divorce, then we could go into court, call our first witness, call the next witness, call the CPS person, call the cop that responded, call our witnesses that we need to build the case as big and strong from the very beginning, and we get to go first. So there's a huge tactical advantage in going first in a hearing, at that first hearing, if you need a very heavy divorce. Those would be the two main advantages, is setting the tone and then being able to go first in your divorce. Filing a divorce is actually fairly simple, but I think it starts well before the initial pleadings. Filing a divorce starts with the mental preparation of getting ready to enter into a new phase of your life. Most people who file for a divorce have been thinking about it for 2 years or more. And so the first year they think about filing a divorce, they have realized their marriage is unhappy, they're not getting the benefits from the marriage they should be giving, and they start letting go emotionally. They'll start falling out of love with their spouse. The second year, they typically will start planning the logistics of what life looks like after a divorce and how am I going to live, pay my bills, pay for a roof over my head, what's my relationship going to be with the children. They start doing all that calculus during that second year. And then sometime after that, they'll actually go and talk to a lawyer. So my advice would be talk to a lawyer earlier than you need. Don't wait until you're ready to pull the trigger on the divorce before you talk to a lawyer. reach out to us and start exploring your opportunities and learning about things you didn't even know you didn't know. Lay straight the path so that when you get to a divorce, you are already on the right track. Okay, so prepare for the divorce before you actually file it. Then when you're ready to file, you meet with your lawyer. We'll go over your goals. We'll start building out a strategy around those goals, and then we'll file the initial pleading in your case. And that initial pleading gets filed with the clerk, will be assigned to court. We'll probably pick up a court date for the initial hearing in that case. And then there's some other, formalities that have to be taken care of. Your spouse, for example, has to be served. They have to have official legal notice that they're being sued for a divorce. You can't just email it to them. You can't just give it to them. It's got to be formalities included to make sure that they are on actual legal formal notice that they're being sued for divorce. Filing a divorce, our recommendation would be to start planning well before you actually hire the lawyer. And then once you hire the lawyer, the rest is just a process. Lots of folks go through it, and we're happy to help you, both in the legal aspects and then the practical aspects of how it affects your life as you go. And then sooner or later, your divorce is going to be over and off you go on the rest of your life. When you finally decide to file for a divorce, it's probably going to be on the grounds of insupportability. In Texas, we're a no-fault state, and insupportability is the word that's in the family code. And it basically just means, the marriage relationship is no longer working. The parties are no longer getting along, and the marriage relationship is not effective anymore. That is really all that is required to file for a divorce. So you don't have to claim that the other party is cheating. You don't have to claim that they've been cruel to you. You don't have to claim they've committed fraud or anything like that. All you have to say is, the marriage isn't working anymore and I want out. You can file for a divorce because it's Tuesday and you want one. So Texas doesn't require that you prove your case. If you want out, the court will eventually grant your divorce. Now, the court may not grant the divorce with the property division that you want. The court may not grant the divorce with the parenting plan that you want. But the court will grant the divorce. What about the other side of that coin? What if you're the other spouse and you don't want the divorce? You just want to keep being married to this person. The court will not require the other spouse to stay married to you. If the other spouse wants a divorce, the divorce is happening. The divorce will be granted. As long as the other party pursues the divorce, they're going to get one. The court is not going to force them to stay married to you against their will, right? And ultimately, why would you want them to? Why would you want to be with someone who doesn't want to be with you back? Okay, so if the other party files for a divorce, they're going to get it. If you're the one who's filing for divorce, understand you don't have to wait until you catch your spouse cheating. You don't have to create an environment where they hit you in the face so that you can say they've been abusive. You don't have to do any of that. You just talk to your lawyer and we file the case and we say the marriage is not working, it's insupportable, and that's all it takes. As far as filing a fault, you're claiming that the other side is at fault for the breakup of the marriage. It can have some benefits under certain circumstances. Sometimes something we will plead for our client is a disproportionate share of the marital estate. In other words, what we're saying is, hey, judge, we want a fair division of the estate, but in our situation, we should get more because of certain facts that have happened during the marriage. So asking for a disproportionate share is saying, I don't think I should be entitled to just 50%. I don't think I should be entitled to just my fair half. I think I should be entitled to more than my half. And if you're going to ask for more than your half, then you need to prove why you're entitled to more than your half. And when we do that, we will often say, part of the reason we deserve more is because it's the other party's fault that we're having to do this divorce. So if we're claiming that they are at fault for the breakup of the marriage, then why? Well, maybe it's because they committed adultery. Maybe it's because they've been abusive. Maybe it's because they've committed fraud during the marriage. They straight up lied to me and they wasted our money over here or over there. Maybe they wasted the community estate. I don't have any retirement anymore because my spouse spent all the money on his or her gambling problem. There's numerous things that we could show the court that would convince the court that you're entitled to more than just half of the marital estate. So sometimes claiming fault in the breakup of the marriage makes sense. That's part of our strategy built around your goals and your facts. So this is another reason why those fill in the blank forms that you get on the internet where, you can go and file your own divorce don't work. This is why you need a lawyer. If you want a disproportionate share of the marital estate, that is not do-it-yourself world. That is, you for sure need a lawyer.